Right, you can see my face is red because I've been stressed out up to the court date and during the court hearing. Now this I've pled not guilty, and I got a trial coming up now on the 23rd of March, and I've verbally resubmitted the motion to suppress evidence. And Judge Owsley said that he's not gonna get rid of it, stop it, but he's gonna deny it until March 23rd. Prosecutor Benjamin is demanding evidence from me, and Judge Owsley is insisting that there's a law that says I have to provide evidence. Even if I'm not going to present any evidence, I have to provide evidence of videos to Prosecutor Benjamin of the incident, even if I'm not going to provide. And I asked Judge Owsley, is this going to violate my Fourth Amendment rights if I present evidence to the prosecution when I don't intend to bring any evidence before the court on my defense? I'm only going to use Prosecutor Benjamin's evidence. He's saying it does not violate the Fourth Amendment, that Prosecutor Benjamin can demand evidence from me in a reciprocation thing, because I demanded the discovery evidence from him. He can. It's legal, but I tried to establish a law. All right, Judge Owsley said it's a law, and I was like, I said I'm not aware of this law, and then I reiterated my Fourth Amendments, and he's saying it's a lawful thing that you have to give the prosecution evidence, even if you're not going to use this evidence at your trial. So what's the deal with that? I have to take another look at my prosecutor's demand for evidence from me. They got more stern with me needing to provide evidence to the prosecution. That's very troubling. All right. Let's see. Out of there's a 521A motion. There's a motion I made that Judge Owsley said is out of date. It had something to do with the discovery, and Judge Owsley said that we were looking at a 2020 rule, and it's been updated since then. It's not 15 days after the trial. It's 30 days after a discovery request. Something like that. Such issues regarding interlocutory, whatever. This is the prosecutor's response. So there's that. I'm trying to remember everything. Let's see, I wrote down notes as best I could. So I pleaded not guilty today, and then we set the trial. Let's see, and everything apparently, like what Judge Owsley likes to do, everything needs to be every motion filed now on paperwork is to be decided on March 23rd. Everything. There's no making rulings before that. I could submit all the paperwork I want and need, but there's nothing that's going to be solved until the trial day now. So everything is falling on this trial day. It's 2.5 weeks away. I have to sit around for 2.5 weeks. The trial court has no evidence before it. They're saying, Judge Owsley is saying, that the affidavit for arrest warrant is not in evidence. It's enough to get me tossed in jail, this affidavit for arrest warrant, but it's not enough. It's not evidence. It's not. My affidavit for arrest warrant was enough. It's like it's in a situation where it's enough to throw me in jail, but it's not enough to rule on. Apparently, it's in this limbo. They have it may be in my criminal case file, but it's not. It's not a part of the evidence. They just they categorize affidavit for arrest warrants as lesser than evidence or testimony. All right, it's enough to decide initially to keep me in jail. They have to write it in 48 hours, but it's not enough to be considered as evidence. So I found that very interesting, how they categorize an affidavit for arrest warrant. Let's see. It was a lot said. Just I have to prepare for a trial. There's the discovery issue where apparently I have to give the prosecutor some videos or whatever. And they're saying, what's the punishment? That's the thing. It may be a lawful thing that I have to provide the prosecution with evidence, but what's the punishment if I don't? Really? I that wasn't made clear, because there's no punishment. That would be a constitutional issue. They said it sounds like I'm preparing my case for an appeal. All right, the way the paperwork is being submitted. Not dismiss, deny. Yeah, a lot of my motions have not been dismissed, but they've been denied at the time, because we're pushing. Judge Owsley is pushing for trial. We need trial. We got to go to trial. We had the arraignment today. That means evidence can now be submitted into court after the arraignment. So then I said, let's resubmit the motion to suppress evidence. And he said he's not going to deny it. He's not going to dismiss it, but he's going to deny it. So he holds there is no dismiss or approve. There is a let's hold it until the trial date. Okay, that's the limbo. Judge Owsley puts the affidavit for arrest warrant into a limbo where it's like outside of the court, and then my motions are put in a limbo where they're not quite dismissed. They're just kind of held in a limbo and held over until trial. A lot of this is like it's stuff that he's not really made any serious rulings on, even after the arraignment. He was really talking about how nothing is submitted to the court before arraignment. There's nothing. We're just bantering back and forth, talking about nonsense, I guess, because there's nothing in the court to go off of, to make any solid ruling on. There's nothing. And then after my arraignment, even still, I could say that there's evidence. Now we could start submitting evidence before the court, but he don't want to make a decision until trial date, until the trial. So it's like all this evidence is not counted as evidence until the trial date. He just kind of holds it all in limbo, lets it all build up, and he wants to make just one big decision at the trial. All right, that's like this how they work here. Is just let's get to the trial. Their end goal, there's the finish line, which is the trial. They don't like to stop short of the finish line. They see the trial as a finish line around here. There's no finish lines before that. So it's quite a unique approach. I don't know what's guiding it exactly. How they are like has it been like this for a long time? I mean, Louisiana's got a bad reputation, so this is a part of their reputation that they're building on. Hold everything for trial. We're not gonna make a solid decision. We'll hold it in limbo, and then push it to trial, and then what? After all that's been said back and forth, then you got that ultimate finish line, and it works. Whose favor does it work in? It works. They're gonna work in a manner that works in their best interest, and that is the trial. They're making money off of me, getting paid by the hour. I'm just sitting around. They're draining my money, fighting this, and yeah, push it out to the trial, whatever. Let's see, attempt at appeal. Oh yeah, and that Cloyd Benjamin, he's talking about proper vehicles and proper form. There's a lot about that. Res judica. This is another. What the heck is a res judica? So I'll just show this for the ending. Is that readable? Talking about vehicles and forms. I'm not using the proper vehicles and forms. So it's all quite stressful. But I don't think they take that into matter. But they're trying to make me show appreciation for what they're doing, and they're not giving me any appreciation for how I'm handling this. All right, I'm being civil. I'm showing up to court dates. Yet it's me who has to appreciate what they're doing for me, with their illegal arrests, and then stringing me along with all this court all these court procedures that I'm not familiar with, especially that I'm required to provide evidence to the prosecutor. I'm his investigator. I'm going to investigate myself for him. This is help.